I'm particularly worried because unlike the authorized use of force original doctrine and legislation passed by the Congress, we limited the authority of the President and the U.S. military to those connected directly to the September 11th mass murder of Americans. And I think in times of emergency, I understand that. But the legislation would be the first congressional authorization to go far beyond that, to say that any person who substantially supported al-Qaeda, the Taliban, or associated forces, undefined, including any person who committed a belligerent act, would be allowed to be picked up by U.S. military authorities and held in U.S. military detention. And while I am in favor of robust and flexible U.S. military action overseas, including action against American citizens waging war against the United States, like Anwar al-Awlaki, I think that we all should agree on a special zone of protection inside the jurisdiction of the United States on behalf of U.S. citizens. Now, I say this in support of the Feinstein Amendment because I took the time, as we all should from time to time serving in this body, to reread the Constitution of the United States yesterday. And the Constitution says quite clearly, in the trial of all crimes, no exception, there shall be a jury, and the trial shall be held in the state where said crimes to have been committed. Clearly, the Founding Fathers were talking about a civilian court of which the U.S. person is brought before in its jurisdiction. They talk about treason against the United States, including war in the United States. And the Constitution says it shall consist only in levying war against them or in adhering to their enemies, giving aid and comfort. The following sentence is instructive. No person, it says, shall be convicted of treason unless on the testimony of two witnesses the same overt act or in confession in open court. And I would say pretty clearly that open court is likely to be civilian court. Further, the Constitution goes on that when a person is charged with treason, a felony or other crime, that person shall be removed to the state having jurisdiction of the crime, once again contemplating civilian state court and not the United States military. As everyone knows, we amended the Constitution many times, and the Fourth Amendment of the Constitution is instructive here. It says the rights of the people to be secure in their persons, houses, papers, effects against unreasonable searches and seizures, including, by the way, the seizure of the person, shall not be violated, and no warrants shall issue except upon probable cause supported by oath or affirmation, particularly describing place to be searched and persons or things to be seized. Now, in Section 1031b2, I do not see the requirement for a civilian judge to issue a warrant. And so it appears that this legislation directly violates the Fourth Amendment of the Constitution with regard to those rights which are inalienable according to the Declaration of Independence and should be inviolate as your birthright as an American citizen. Recall the Fifth Amendment, which says no person, by the way, remember, no person, there's not an exception here, no person shall be held to answer for capital or otherwise infamous crime unless upon presentment and indictment, oh, hear the words, grand jury, except in cases arising of the land or naval forces or militia when in actual service in time of war, meaning that there is a separate jurisdiction for U.S. citizens who are in the uniformed service of the United States. But unless you are in the service of the United States, you are one of those no persons who shall be answerable for a capital or infamous crime except on indictment of a grand jury. The Sixth Amendment says that in all criminal prosecutions, not some, not by exception, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. I go on to these because I regard all of these rights as inherent to U.S. citizens, granted to them by their birth in the United States. And if we go on through the Constitution and its amendments, we find in the 14th Amendment, it says that no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. Now, I realize that these powers have been defined by courts. But we would recall that even Abraham Lincoln, ex post facto, lost his ability to suspend the writ of habeas corpus pursuant to a Supreme Court decision. That we had in the case of Handy v. Rumsfeld. The court did recognize that under the 2001 statute, the president is authorized to detain persons captured while fighting U.S. forces in Afghanistan. But I will recall, and by the way, this included American citizens, I recall that was in Afghanistan. Clearly, we see in a case where an American citizen has gone to a foreign jurisdiction, joined a terrorist organization or foreign military, and is waging war on the United States, they could be held as a detainee of the U.S. military. Why didn't this legislation say that? Why didn't it restrict its purview to those provisions? In Padilla versus Hanif, the Fourth Circuit did allow the capture of a United States citizen, Padilla, by the way, arrested at O'Hare Airport, a United States citizen, and held in military detention. And the Fourth Circuit said because he had foreign training and a foreign connection, that it was legal to hold him. But remember, very soon thereafter, the Bush administration surrendered this case. I think the Bush administration realized they were about to lose in the Supreme Court on the subject of whether the U.S. military could arrest and detain a United States citizen and to deprive them of their rights and subject them only to review under a petition of habeas corpus. I think they realized that they had to kick Padilla into the civilian court system, and therefore they did. And it's only in that context that we should read the Padilla's decision. I think bottom line is this. We funded a multi-hundred billion dollar Department of Defense, in the words of the movie, to put men on that wall, that you need on that wall, to defend us against foreign threats, and that they must do hard and difficult things, including sometimes to United States citizens, like Anwar al-Awlaki, that are waging war upon the United States from a terrorist base in Yemen. But the whole purpose of this exercise and this institution is to defend the rights of the United States and U.S. citizens inside their own country. One of the first things you do when you join the U.S. military is not to swear allegiance to a president or to a foreign leader. You actually swear allegiance to the Constitution of the United States and to the rights that it has. What is the whole purpose of the Constitution? It is to defend your rights against the government, because we are one of those unique governments that posits a limited government in which rights are reserved, according to the 10th Amendment, to the states or to individuals, that your rights supersede the government. And so we cannot say for an individual, for example, in Wisconsin, who's never been abroad, who may or may not have committed an act, or may not have one association, that suddenly the United States military can roll in on that person, seize him or her, hold them in military detention, and only subject review of that case by one habeas corpus petition. I would argue then that all of your rights as an American citizen hang on the decision of the President of the United States. That if the President of the United States decides that you are substantially part of al-Qaeda, the Taliban, or associated forces engaged in hostilities against the United States, or you committed a belligerent act or supported such hostilities in aid of such forces, that all of your rights as an American citizen are now forfeit. Clearly, that's not the case. The Founding Fathers understood the power of the state run amok under a distant king that did not regard the rights of the individual as worth much. We founded a republic and then wrote a constitution to defend those rights. And while we face a very difficult and dangerous world overseas and have to do difficult and dangerous things, which I support, we should make sure that there is a place for peace and justice and rights inside the United States. And so for us, in looking at this provision, the Feinstein Amendment clearly limits the scope of this legislation in an appropriate way, that we do the difficult things overseas. But the whole purpose of the Department of Defense is to defend the United States and those rights inside our country. But that you, as a U.S. citizen, especially when you are inside this country, have inalienable rights which cannot be separated from you by any executive action. That you can only be held, incarcerated, that you can only have your liberties taken away from you on indictment of a grand jury before a civilian court, and with a presumption beyond a reasonable doubt by unanimous vote of that jury. That is the essence of who you are as an American. And it is a historic decision that we would make here if we allowed this power to go forward. I think that's why Senator Paul and I were the only two Republicans to vote against it. That's why so many emails and letters that I've received in the last few hours support this decision. And I understand that others have a different view. They describe the United States as a battlefield. And I would say that that is an overly harsh determination of how cheaply our rights can be held. That we have a multi-hundred-billion-dollar Department of Homeland Defense. That we have a substantial and capable FBI. That we have enormous state and city and local police establishments, all with the capability to investigate and prosecute crimes, but under the Constitution of the United States. And that if we hold U.S. citizens as capable of losing their rights on an executive branch decision, that it is that not beyond the shadow of a doubt, but on a lower standard of care, that in the executive branch's view, you are connected to one of these things, then your rights are not worth very much. I would say the whole purpose of the Constitution is to hold your rights higher than the government and subject only to review by a civilian court. And that review, as described in the Constitution of the United States, is far more than a habeas corpus review. The text of the Constitution specifically refers to grand jury indictment. For those who have questions on this, I would urge them first, take a moment to reread the Constitution. That first document which, as a member of the U.S. military or as an elected member of this body, you have to swear allegiance to. And then make up your mind. I think when you do, you will support the Feinstein Amendment. And I yield back.
President.